Now, the first case I wish to consider and discuss this morning is Wasa against Lexington. Now, the case is an important one. It's going to the House of Lords in May 2009. It will be the first proper reinsurance case, in my view, to be heard by the House of Lords since the film finance cases, which were heard in 2003. So I think insurance and reinsurance lawyers generally are quite excited to see how the House of Lords handle this dispute. If I can just perhaps briefly outline the facts. In 1977, Lexington, an insurer, issued an insurance policy covering losses occurring during a 3-year period, protecting Alcoa, a US assured. The policy in question contained a US service of suit clause and provided that the policy would be governed by the law at the place of suit. Now, Lexington bought facultative reinsurance in the London market in 1977 from Wasa. The reinsurance slip contained a standard follow settlements clause. The reinsurance slip also stated that it covered losses occurring during the period 1977 to 1980, which was the 3-year period also covered by the policy written by Lexington. The reinsurance contract was governed by English law by implication, not expressly. Now, the problem arose because in 2005, a US court held Lexington liable to Alcoa under the insurance policy to pay pollution cleanup costs for pollution which had taken place both prior to and during the period of insurance provided by Lexington at various Alcoa sites in the States. The United States court did this and held Lexington so liable because the case law in Pennsylvania, which the US court held to be the proper law of the insurance policy, developed long after 1977 when the policy was first written, provided that if there was some pollution damage during the period of insurance afforded by a policy, that policy is obliged to pay for all pollution damage, whether occurring before or during the period of insurance, because of the difficulty of identifying what damage was caused by pollution during as opposed to prior to the period of insurance. Having settled quantum, Lexington then sought to recover its share of the settlement from Wasa in London. Wasa refused to pay anything, arguing that the settlement plainly covered damage which occurred before the period stated in the reinsurance slip, which is undoubtedly true. At first instance in the commercial court, Mr. Justice Simon found for Wasa and Lexington lost. The importance of the period of cover stated in the reinsurance slip prevailed over any obligation to follow Lexington's settlement with Alcoa. In effect, the court at first instance held that Lexington could only recover a proportion of the settlement which reflected actual damage which had occurred during the period of reinsurance. Because Lexington couldn't show that and couldn't show in any event that that would exceed the deductible in the reinsurance contract, Lexington lost. The Court of Appeal gave permission to appeal, and in the Court of Appeal, Lexington won. The Court of Appeal held that the period of cover in the insurance and in the reinsurance was intended to be the same. Accordingly, Wasa, as reinsurer, was bound by the determination of the US court that Lexington, as insurer, covered damage which occurred prior to as well as during the period of insurance. So the scene is set for an appeal to the House of Lords. The judgments of the Court of Appeal included a judgment of Lord Justice Sedley, who I think would be the first to admit he is not an insurance and reinsurance law specialist. If the House of Lords proceeds in the way that Lord Justice Sedley determined the dispute in the Court of Appeal, then, in my view, the House of Lords will be considering the very heart of the issues about reinsurance law. It's possible, however, that the House of Lords will proceed on a slightly more narrow view, the view held by Lord Justice Longmore, which confines perhaps the dispute to the terms of the specific reinsurance contract and the specific context of facultative reinsurance. If the House of Lords proceeds in that way, maybe the judgments will not be particularly significant for insurance and reinsurance law generally. But we'll have to wait and see. I'm not a betting man, I can't afford to be, but in my view, the House of Lords will uphold the Court of Appeal's judgment, and Lexington will be allowed to recover.